Hello aspirants, as a part of our Indian Constitution module for the competitive examinations, today our chapter is to know about the characteristic features of Indian Constitution. Characteristic features of Indian Constitution. We can also simply call as the features of Indian Constitution. Okay, so this is our topic. So basically the Constitution of India was adopted by the Constitution Assembly on 26th November 1949 and it got enforced, means came into operation from 26th January 1950. So here you need to understand that the formation of Constitution Assembly, there are many committees related to that, and in that the major committee is your drafting committee headed by your Dr. B.R. Ambedkar. So Dr. B.R. Ambedkar's committee, also called drafting committee, so where the major responsibility and purpose behind that formation of that committee was to draft the Indian Constitution, and that draft is nothing but your preamble. So basically what happened, after the formation of your Constitution Assembly through the direct elections, which is the promise which was fulfilled by the British to India, J.L. Nehru introduced objectives resolution, and this objectives resolution came from three important revolutions and the experiences of our Indian context as well, and in that the major one was your American Revolution, Russian Revolution and French Revolution. Based on these three revolutions, with the concept of the pillars of democracy, let me say the pillars of democracy, in other words we can also call as the main important features like liberty, equality, fraternity and justice as the pillars. J.L. Nehru is that fellow who introduced objectives resolution in the Constitution Assembly, and it was adopted by the Constitution Assembly, and thus preamble came into picture. Okay, preamble came into picture, which is also called as the face of Indian Constitution, but technically we can call that as the philosophical foundation for Indian Constitution. So based on that philosophical foundation called preamble, the features of Indian Constitution is that part which is being asking as a part of your syllabus, and hence we are concentrating on that. And now here you need to understand this is the product of the wisdom of the statesmen who were the members of your Constitution Assembly of around 308 members, where your All India Muslim League completely boycotted the sessions of your Constitution Assembly, and hence there is no role played by the All India Muslim League members who got elected in the elections by that time. So here there are many other constitutions which were referred by B.R. Ambedkar and his team, and from there we collectively adopted some important features with respect to the Indian context and the Indian aspirations. Based on that, our constitution was designed, and it is not the copy and paste methods. Okay, so that is not a part of our syllabus, and hence we are not concentrating on that. So now let us discuss the characteristic features of Indian Constitution. Okay, so the characteristic features of Indian Constitution is nothing but understanding the preamble itself. Okay, so the source for the power in India, from where we derive the power, in the sense it is the power we can derive from the people of India itself, because the preamble is saying we the people of India, and the last lines of your preamble is also saying hereby do adopt, enact and give to ourselves thus constitution. So connecting the dots of we the people of India and adopt to ourselves thus constitution is clearly making a sense of understanding that the source of power in India was the people itself. Okay, so now coming to the features, the first important feature of Indian constitution, basically there are 15 to 18 important features, and in that the first one is written constitution. Written constitution. Okay, so written constitution, basically there are two types of constitutions in the world. One is written, second one is unwritten. So what exactly do you mean by written constitution? In the sense, if there is a special body exclusively made to draft the constitution of a country, and thus constitution which drafted by that specially formed body, then we can call that constitution as the written constitution. Okay, and the best example for that is your America. America is the American constitution was the first written constitution in the world, where a special body was formed by the time called Philadelphia Convention. So based on that, inspired from that, even India adopted the same and hence we are having our own special body to design, to draft our own Indian constitution called Constitution Assembly. So the major purpose, objective, vision, mission, everything of your Constitution Assembly is to draft our Indian constitution according to the aspirations of the people. And hence we can say that Indian constitution is a written constitution in the world. And you know what? It is the biggest written constitution as of now in the democratic countries of the world. And you know what? When we are talking about written constitution in India, we are having written constitution. Under this, we are having 12 schedules, 24 parts, and often around 409 articles, And you know what? As of now, there are more than 100 amendments which were made. Okay, amendments which were made to the Indian constitution, and hence we can say the written constitution in the world, the biggest in the world, is our Indian constitution itself. And you know what? India is a republican country, which is where our head of the state called President of India is being elected for a particular period of time according to the constitution, and hence we can call India as a republican country. So the Republic of India is having the first feature called written constitution. And you know what? The second important feature for this is the longest known constitution in the world. So basically there were 395 articles along with 8 schedules in the original constitution by the time when it got drafted and adopted by the country. Okay, so now it was seen like this, having 12 schedules, 24 parts and 409 articles. Okay, so now the point here is it is the longest known written constitution in the world. So this is the first feature which we need to focus. And now the second important feature here you need to understand. For the drafting of Indian constitution, there are two important factors which we rely on. That one is your geographical factors, second is your historical factors. So the influence of the Government of India Act 1935 is the historical factor which we can say, and the geographical factors like the vastness of the country with respect to the diversities, and that having diversities and equal representation to be given to the people of India. For that context, we adopted parliamentary system of government. Okay, so understanding written constitution as the lengthiest constitution, as the biggest constitution in the world, this is the point you need to remember. Okay, so after this there is a second important feature. It was drawn from various sources. Okay, it was drawn from various sources. So you need to understand, as we are saying that it was drawn from various sources, in other words we can say that we borrowed that suitable points, that suitable concepts of different constitutions of the world. So basically what historians used to say, that B.R. Ambedkar along with his team with the support of the Constitution Assembly referred more than 68 constitutions in the world, and for that 68 lakh rupees was also spent as an expenditure, and it took 2 years, 11 months and 18 days 2 years, 11 months and 18 days to draft our Indian constitution. And hence in this context you need to understand from what are the different sources of Indian constitution, and in that we are having your America, Irish constitution, Britain constitution, okay, South Africa, USSR, Germany. Okay, likewise there are different sources, and especially from 1935 Government of India Act. So in the last chapter when we discussed about 1935 Government of India Act with respect to the federal features, there you came to know that 80 to 85% of the Indian constitution was literally taken from the 1935 Government of India Act, and hence you need to understand that in this context. So B.R. Ambedkar is that fellow who claimed that the Constitution of India is not just a copy-paste constitution. Okay, the most important features which could reach the aspirations of the people of India, taking geographical factors as well as historical factors into criteria, we drafted this. So this is the statement literally given by your B.R. Ambedkar. Okay, and hence you can say the structural part of the Indian constitution is very vast. Okay, not only the structural part of Indian constitution but also the philosophical part of Indian constitution derived from Government of India Act 1935 itself. And parliamentary system of government, the political part, let me say the political part of the Indian constitution, from the like the principles of cabinet government, formation of cabinet, portfolio system, okay, all these we have adopted as a part of this 1935 Government of India Act itself. Not only that, as a next important feature, it can be seen as a blend of both flexible and rigidity. Okay, so both flexible and rigid concepts also taken into picture. In other words, we can say that there are some important features of the Indian constitution. While a bill is becoming an act, we use it to follow some majorities, and according to the conceptual level, okay, constitutions are of again categorized into two different types. One is your rigid constitution, second is your flexible constitution. In other words, we can say it is very easy to amend the constitution, falls under your flexible characteristic, whereas it is somewhat difficult. Okay, I am not saying that it is not possible, I am not saying that it is impossible, I am saying that it is somewhat difficult, with a name called special majority is required for the rigidity type of constitution to flourish. And hence we can say in India, the combination of both the rigidity and the flexible features can be seen as a part of our constitution. Means simple majority and types of special majority, 4 types of special majorities could be seen as a part of our constitution itself. And now this so-called flexible feature was adopted from the British, whereas the rigidity feature was adopted from different sources. Okay, and now we can also say, based on this flexible and rigidity features itself, as a important chapter, the last 5th unit of your syllabus is talking about amendment process of the Indian constitution through Article 368. Okay, there I will connect the dots to understand it better. When we are talking about types of majorities, there you will come across that. Okay, and then comes the next important feature, federal structure. India is having the federal structure, federal system with unitary bias. The Constitution of India, through 1935 Government of India Act, we adopted the federal structure for the first time in India under the British, and it has been continuing in India to have the same federal structure. But you cannot say that it is absolute federal, true federal, like your American constitution. The best example for federal complete federal structure is your American constitution, but it is not so with respect to India. So under article 1 of Indian constitution, you will come to know article 1, India shall be the Bharat will be the union of states. India, that is Bharat, shall be the union of the states, where we used the word union there but not federal, and hence from that it is very clear that we are having federal features. Then that doesn't mean that India is a true federal in form. India is having that potentiality to hold the complete as a union. Okay, and now the constitution has variously described as federal in form but unitary in spirit. Okay, federal in form and unitary in spirit, which was given as a statement by your K.C. Ware. This is very, very important for your examination, mains examination. K.C. Ware is that fellow who used to give that statement that the Indian constitution is having federal features with a spirit of unitary. Okay, with a spirit of unitary. Okay, K.C. Ware is that fellow, and this is what the most important point. So federalism in India is a new chapter which you could come across in your economy part, as well as we are trying to give you the same content in the different aspect of governance, federal governance, cooperative federalism type of context under Niti Ayog's functioning. Okay, there we can connect the dots. So this is what the fourth important feature, and the next important feature is your parliamentary form of government. Okay, parliamentary form of government. This is very, very important to understand. Parliamentary form of government. Okay, basically government is having what? Three important organs, right? Three important organs called legislative, executive and judiciary. Okay, as a part of that parliamentary form of government, we can also call this as a responsible form of government. Okay, responsible form of government. So what exactly do you mean by this? What exactly do we mean by this in the sense? That the executive is collectively responsible for the legislature. Let me say, for our understanding, that the Parliament of India members called MPs of both Lok Sabha and Rajya Sabha could question the executive. It is their right to question the executive with respect to the problems and challenges of the society, and it is the responsibility of the executive to answer that, and hence we can call this as responsible form of government, which is one of the most important feature of Indian constitution. And you know what? And this so-called parliamentary system of government as the feature of Indian constitution, we adopted from Britain. Okay, and hence the British Parliament was called as Westminster, and hence this model is also called as Westminster's model. Okay, Westminster's model. And as we adopted from the Britain, it doesn't mean that the same true features of British Parliament could be available in India. It is somewhat different in the context. When we are learning about, learn about your parliamentary structure, functions, roles, responsibilities, then you will come to know that. And now here try to understand the difference between the presidential form of government and parliamentary form of government. Here, why we adopted parliamentary form of government in the sense representation from all the diversities without excluding any community, without excluding any diversity of India, we adopted parliamentary form of government. And hence, as we are giving preference to the representatives there, as we are forming the government based on the representatives of the people from a constituency, this so-called parliamentary form of government is also thus called as a responsible form of government and representative form of government, or representative form of democracy. Representative form of government or democracy. Okay, representative form of democracy. Okay, so this is the point which you need to understand. And as we said, what are the features of this parliamentary form of government in India? So very, very important features we could come across. The features of parliamentary form of government. Parliamentary form of government. The features of parliamentary form of government. Okay, the features of parliamentary form of government could be observed. The features of parliamentary form of government could be observed in basically with 5 to 6 important points. The first important point here is presence of real and nominal executives. Okay, real and nominal executives. Okay, the real executive is your prime minister, nominal executive is your president of India. This is the first important feature, and the second important feature is majority party rule. Majority party rule can be seen. Okay, based on majority itself, we can call that as absolute majority. Absolute majority in the sense 50% plus 1. More than 50% of the majority of the house from a party could form the government. Okay, majority party rule. And then the next is ministers could be seen as the members of the legislature. Okay, ministers. So in order to become ministers, one should be the membership. One should be the member of Parliament of India, either Lok Sabha or Rajya Sabha. Without having any membership, one cannot become a minister. This is what the next important feature. And the next important feature, this so-called ministers are collectively responsible for Lok Sabha. Lok Sabha is nothing but lower house, people house. In other words, we can say these are collectively responsible to the people directly. And if they are not having that responsibility, we can again recall them with the name called some motions. No confidence motion can be initiated. Okay, so this is another important feature. And then the next important feature is Lok Sabha or the state assembly can easily dissolved. Okay, Lok Sabha or the state assembly could be dissolved at any point of time if there is no majority. Okay, so if there is no majority, in the sense if there is no support to the government which is existing, okay, it can be easily dissolved. So dissolving, we can say from this we can say that the Lok Sabha and the state assemblies are temporary. They don't have any particular time period. Okay, according to the constitution, I am saying, according to the constitution, 5 years is not the tenure, it is still the confidence which they could gain. Okay, not only that, the next important the leader of the house the leader of the house could be your prime minister or the chief minister. Okay, the leader of the house will be the prime minister or chief minister. I am not talking about the presiding officer, the constitutional position called speaker. I am talking about the leader. So this is one of the important feature for your parliamentary form of government. And then the basic difference between the British Parliament and Indian Parliament, even though we adopted from that Westminster model of government, there is a difference. What is that? The British government, the British Parliament is a sovereign body, whereas the Indian Parliament is not a sovereign body. I hope I am clear. The British Parliament is a sovereign body, whereas the Indian Parliament is not a sovereign body. What do you mean by sovereignty? Sovereignty is nothing but what? While taking decisions, no influence or motivations, no interference by the external people. Okay, so that is what we call it as sovereignty. So British Parliament is a sovereign body, whereas Indian Parliament is not a sovereign body. And now finally, the parliamentary government combined with the elected president as the head, nothing but another most important feature, elected head of the state. So the elected head of the state is nothing but president is going to be elected. Okay, president is going to be elected. This is what the point is. Okay, so these are the features sub features of your parliamentary form of government. And then comes, there is another important feature for Indian constitution, that it is having independent judiciary. Okay, independent judiciary. Independent judiciary doesn't mean that this so-called judiciary system of India, union judiciary system of India is not answerable, is not accountable. It means that no one is having that authority to interfere into the judgments, to interfere into the proceedings of the court. Okay, and the Supreme Court or the Union Judiciary is answerable, means is accountable to the Constitution of India. It cannot act as a monarch there, and hence we can say independent judiciary we adopted from the Dicey's theory of principles of natural justice. So independent judiciary is one among that features of Indian Constitution. Not only that, parliamentary sovereignty. Okay, parliamentary sovereignty. So the synthesis of these two is more important. So parliamentary sovereignty over independence of the judiciary, there are some clashes. Under center-state relations, you will come to know that. We are going to discuss deeply at that point of time, but keep this point in your mind, that this parliamentary sovereignty and the independence of the judiciary, the supremacy of the judiciary, there are some important points where 21st article of your fundamental right, all these taken into picture. And this independent judiciary, judicial review as the power of the Supreme Court, I mean the judiciary system in India, all we adopted from USA. Okay, we adopted from USA. Parliamentary form we adopted from Britain. A judiciary system and related matters, most of the matters were adopted from your USA. Okay, and now what exactly do you mean by this synthesis, in the sense that the Supreme Court is having the power to look into the laws or the decisions taken by the Parliament of India to say whether those were constitutionally valid or not. So to check into this parliamentary supremacy, I mean parliamentary sovereignty, even though we say judicial supremacy can be made. So here the decision taken by the court is to be respected, honored, and to be implemented at any cost. Okay, and if it is not going on, then we can say that it falls under as the contempt of the court. Finally, this is what one of the most important point. And then comes the next important is your rule of law. Okay, next important feature, rule of law. Okay, rule of law. So this is the most important point which we adopted from your Britain Constitution again. So what exactly do you mean by rule of law? Rule of law according to axiom. Okay, according to axiom. Okay, the people are ruled by law but not by men. Okay, according to the axiom, we can say that the people are ruled by law but not by the men. So whichever the government, which party at the center or at the states can form the government, it is not about the governments which are thus forming it is the rules which are making the people to move forward, to develop, to grow. And hence keep this point, rule of law is nothing but what? Laws are going to be made for the protection of the citizens of the country, and hence rule of law can be seen as a part of that. And there is no room for the arbitrariness. Okay, according to this, there is no room for the arbitrariness. If each and every individual enjoys some fundamental rights, likewise each and every individual are also having some duties to perform on the other side. Right from 1942 you can observe this. Okay, fundamental rights cannot be harnessed at any cost, cannot be affected, cannot be violated at any cost in India. Are you getting? And for that reason, we adopted democracy as the next important feature. Democracy as next important feature. And you know it very well, according to Abraham Lincoln, democracy means the rule to the people, by the people, and for the people. Okay, but according to our Prime Minister, Honorable Prime Minister Modi ji, and another word as a part of the Man Ki Baat of your Modi, it was clearly stated it is not just the rule to the people, by the people, for the people, but it also added the rule which is to be focused for the better development of the society. So in that context we can say it is not just the rule to the people, by the people and for the people by your Abraham Lincoln concept, but also the rule with the people, within the people also falls under the definition of your democracy. So demos plus kratia, nothing but demos means people, kratia means ruling. The people are the rulers, and that is the concept of your democracy there. And now rule of law was clearly mentioned under your 14th article of your third part of Indian Constitution called fundamental rights. Okay, 14A and 14B are the two articles which are talking about rule of law. What it is saying, you know, all are equal before the law. All are equal before the law. Okay, not only that, a law to be made to protect the people, not to harness or affect the people aspirations. That is what your 14th article is clearly mentioning about. And now after this integrated and independent judiciary is next important feature. Independent and integrated judiciary with judicial review as the power of the court. So this is that which we adopted from Professor A.V. Dicey, the theory of principles of natural justice. So integrated and independent judiciary to be free from the influence of the executive and the legislature. No one is having that power to interfere into the judicial matters so-called concerned. Okay, not only that, it is ensuring, Constitution of India is ensuring that the independence of the judiciary is mandatory, and hence you can say the recent judgment of the Supreme Court, which it clearly ruled that the National Judicial Appointments Commission, okay, NJAC, which replaced the collegium system for the appointment of judges, is unconstitutional. It is not valid. Are you getting? So that clearly stated that the independence of the judiciary is much more important. Fine. And then comes the next important feature of Indian Constitution. It is having fundamental rights. Okay, as a part of your third part of Indian Constitution, fundamental rights. So wherever the country want to flourish, there the fundamental rights are more important, which are justiciable in nature, which are legal in nature, which is providing concentrating on the human rights to protect, to establish egalitarian society, to establish the utopia society, to establish a society without having any gaps and discriminations. What is required? Rights are required. Fundamental rights. The more fundamental rights, what fundamental rights providing by the country, we can easily draw a conclusion to analyze what type of political structure it is following, what type of country it was. Okay, such a great importance was given to fundamental rights, and that is where you need to understand. And no majority has the right to abrogate the fundamental rights. Okay, no majority party or no majorities are having, all are equal. All the citizens of India are going to provide the equal and the same fundamental rights. Okay, so fundamental rights can be seen in this context as the feature of Indian Constitution. And as we said that these are justiciable in nature, if when violated, the aggrieved person can directly go and knock the doors of the Supreme Court according to Article 32. They can also go and knock the doors of High Court according to Article 226. In other words, we can say for our understanding that the courts are there, always opening the doors for the citizens when they are affecting by the violation of the fundamental rights, either by the government or by any other individual. Okay, so this is what fundamental rights as one of the feature. And then after fundamental rights, there is another feature called DPSP, Directive Principles of State Policy. where these are the guidelines, these are the directions given by the constitution to the state or the government to ensure the social and economic justice to the people. So to provide social and economic justice to the people, what the government, irrespective of the party philosophies which they are having, irrespective of the members of the party which they are thus forming the government, any type of government which is there existing, which is there forming based on the majorities, they should follow some functions, they should follow some directions, and that is meant to say as the directive principles of state policy, which was clearly stated as a novel feature, NOVEL, okay, which was considered as a novel feature of Indian Constitution by your B.R. Ambedkar. And it is also clearly stated that to provide social and economic justice to the people of India, it is mandatory that can be seen as the major responsibility and objective before the governments, either at the center or at the states. And hence DPSP can be seen as one of the important feature. And you know what? DPSPs, directive principles of state policies, are non-justiciable in nature. In other words, we can say that these are not legally confined. We cannot go and knock the doors of the courts as if in the case of your fundamental rights violation. Fine. And then comes the next important feature is fundamental duties. Fundamental duties. Your 42nd Constitutional Amendment Act 1976, also called mini constitution, also called Indira Constitution, okay, popularly called Indira Constitution, created Part 4A. Part 4A. Under this 51A is that article which is talking about fundamental duties. According to the statement given by your Indira Gandhi, the citizens of India don't have that right to claim for the fundamental rights if they fail to perform the duties. And this is the point which was highlighted the first time in the world by your Japanese. Okay, so it is not exactly we adopted from the Japanese, but this is that where the government of Japan as of now is being following. So if you as a citizen of India failed to perform your duty, you were not subjected to claim for the fundamental rights, and it is true which is required as of now, because every time we come across the events which are happening, unlawful events which are happening in India, that there are some groups in our India internally which is deteriorating the reputation of India, thus by lighting the fire to the national flag, where they are not at all intended to show some respect on the national flag, national anthem, or the so-called freedom fighters and all. So these are to be deported from India at any cost. So in that context, as a relevant point, the Indira Gandhi statement is to be accepted and to be honored and to be implemented at any cost. Okay, so fundamental duties can also be seen as a part of one of the feature of Indian Constitution, but not as a part of your original Constitution, but through 42nd Amendment Act it was placed. And the next important feature is secularism. Okay, secularism is one of that important feature of Indian Constitution. So basically secularism is nothing but what you know, not to uphold any particular religion as the official religion for the state. In other words, we can say secularism is a great context, is a great platform where the religion is not having any right to interfere into the state affairs, into the government decision making. Is it clear? And hence you can say religion is different and the state is different in decision making. Whereas in the context of Indian secularism, vice versa is not possible. Vice versa is not possible. In other words, we can say the state is not having any official religion to follow, but in other words, we should also understand that the state is there intended to provide equal respect to all the citizens with respect to the religion. So equal representation, equal respect and honor to all the citizens was made available as a part of Indian secularism as the feature. Okay, so this is what secularism intended to. Okay, and no discrimination is to be shown on any type of religion by the state is also falls under the definition of secularism. And then positive concept of secularism is the word which we have taken as a part of our Indian constitution feature with the concept resembling tolerance as the subject. Okay, so India is that only country which I personally believe that religious tolerance, religious harmony is being maintaining. But still there are some groups in India which are literally creating some disturbances by using the religious card there, which is not to be encouraged and not to be tolerated at any cost. And the government's major challenges to tackle that will fall under your internal security challenges as well. Okay, and then comes we are having the next important feature as a universal adult franchise. J.L. Nehru is that fellow who introduced demanded through your INC before the British as a part of British Indian context itself, means prior to your independence itself. Universal adult franchise means irrespective of the class, creed, race, religion or other type of so-called discriminatory issues which are there existing in the society, keeping all these aside, only taking age as the factor, right to vote is to be provided to the citizens of our country. And as of now, the citizens are being provided the right to vote according to Article 324, the power, the responsibility of the Election Commission of India to provide them the right to vote for the elections, to participate in the elections as a political right through your universal adult franchise. Previously it was 21 years, but later on it got reduced to 18 years. One should complete 18 years, register under Election Commission of India. You will be provided that right to vote in the elections. Okay, and this is what universal adult franchise. Okay, then through this universal adult franchise, political equality could be sustained. Political equality could be sustained. And then comes the next important feature is your single citizenship. Okay, single citizenship. So in a federal state, usually citizens enjoy double citizenship. Okay, so if you go to America, as it is a true federal state, best example, there if you go to any state of America, there they enjoy the USA citizenship as well as the state of USA, United Nations citizenship as well. Likewise, as India, to say that India is adopted the unitary feature, okay, unitary in spirit, even though some features law of federal structure can resemble as a part of Indian characteristic features, we can say that this is the best example to understand. So single citizenship in India, there is only one single citizenship to be provided to the citizens of India. So wherever you go, if they could ask the nationality, we can say that we are Indians. You cannot say that I am a Tamilian, I am an Andhra, I am a Telanganite, I am a Keralian, I am a Kannadigan. Are you getting? These type of things were not at all to be tolerated, which is affecting to the unity of the people, and hence we adopted what? Single citizenship. Okay. Is it clear? And hence we can say equality rights could be possible through this single citizenship concept itself. And hence the constitution of India deliberately opted for single citizenship to eliminate the regionalism, okay, to eliminate the regionalism and other disintegrating tendencies which can affect the unitary feature, which can affect the spirit of nationalism in India. And hence we adopted what? Single citizenship, which is one of the feature. And then comes, we are having independent bodies. Independent bodies. So it is not just the formation of legislative, executive and judiciary organs, judiciary as the organs of your government, but also there are some independent parts where deliberately opted for the center and state to establish the independent bodies and autonomous bodies. And hence we can say CAG is an independent body, Election Commission of India is an independent body. Likewise, these independent bodies are thus formed as the democratic institutions to protect and provide the democratic values and awareness and the spirit of democracy among the people of India. So this is what one of the important feature. And then the next important feature is emergency provisions. Emergency provisions. So keep a point in your mind. Emergency provision could be used by the Parliament of India with the name called three types of emergencies, which are the powers of the President of India. But here President is just a nominal executive, where the real power was in the hands of your real executive called Prime Minister, or so-called Council of Ministers, let me say the central government. So on the recommendation of the Prime Minister or the Cabinet, okay, written recommendation of the Cabinet according to 44th Amendment Act 1978, a President can exercise his power called emergency power, where proclamation of emergency could be possible. And keep a point in your mind, emergencies are to be used as the weapons to establish democracy, but not to harness the democracy. This is the original spirit behind the structure of our constitution. But in reality, because for the political gains, or because of the political interferences which are rising day by day, okay, year by year, decade by decade, right from 1950s to till date, these emergencies was used as a weapon to kill the democratic spirit in India, which is not to be tolerated. But from the past 5 to 7 years, again the spirit of democracy is being exercised, is being established by protecting the values of the democracy, by giving awareness to the people of India. So now, coming to the emergency provisions, the constitution clearly made three important articles with related to these emergency provisions. One is your 352 called national emergency. 356 is that article which is talking about presidential rule, and 360 is that article which is talking about the financial emergency, and the rationality behind this, behind the incorporation of the provisions is to safeguard the sovereignty, unity among the people, and the security of the nation. Okay, not only that, even for the democratic political system to get strengthened, these are the provisions which were inculcated as a part of our Indian constitution. Fine. And as a part of this, for the first time we can say that these emergency provisions are the most important criteria, which is now, as of now, in the current scenario, as a contemporary affair from the past 2 years with respect to your northeastern states. So if you do opt for civil services, just focus on that as well. Okay. And then comes the next important feature of Indian constitution is federal structure. It is having federal structure. But here you need to understand, India is that only country as of now in the world where it is following three-tier federal structure. In other words, we can say central government, state government, and local bodies. So first tier, second tier, third tier. So three-tier federal structure could be observed as one of the key important feature of Indian constitution. And now this is a part, okay, which was got inserted as a part of Indian political structure with the 73rd and 74th constitutional amendment acts. 73rd is talking about your Panchayati Raj institutions. 74th is talking about municipalities and municipal corporations. Okay, 8 types of municipalities or urban governments, let me say. Okay, so this is what your points. And through the 74th, 9th A and 9B parts were got inserted. 11th and 12th schedules were also got introduced, okay, inserted in the Indian constitution. And then comes the next important feature is cooperative societies. The next important features is your cooperative societies. This is a most important chapter as a part of your governance. In detail we can go through. So here let us understand cooperative societies. Cooperative societies are those which got inserted through 97th 97th Constitutional Amendment Act. 97th Constitutional Amendment Act 2011. 11 onwards. Okay. Through which gave the constitutional status for the protection of cooperative societies. And from this there are three important changes. What is that? 19th article. Okay. What is that? 19th article, which is a fundamental right, freedom right, we can say. So through 19th article, 19 of C is that article which is there giving the right to the citizens of India to form cooperative societies. And the second important change is under your DPSP, according to article 43 of B, a Gandhian principle, okay, which is also empowering the promotion of cooperative societies as the responsibilities of the state. And finally we can say part 9b, okay, part 9b in the constitution, which was entitled with the cooperative societies in India. Okay, that is the title, the cooperative societies in India, according to articles 243 ZH to 243 ZT, which is talking about your cooperative societies. Okay, so cooperative societies are more important, where it empowers the Parliament of India in respect to multi-state cooperations. Okay, multi-state cooperations and coordinations among the societies, and the state legislature is also empowered thus by forming the other corporations or the cooperative societies for the upliftment of vulnerable, weaker and destitutes of the society. So these are the points of your features of Indian Constitution. And final feature, which is nothing but the philosophy of the Constitution. So basically January 22nd 1947, January 22nd 1947 is that year where your Constitution Assembly adopted the objectives resolution, which was introduced by your J.L. Nehru on December 13th 1946. Okay, so this is the date, adoption of objectives resolution. And this objectives resolution set forth the concept of the idea of political ideologies of India. Okay, political ideologies of India, and it empowers the Parliament with some principles, saying that India is to be independent, that India is to be sovereign, that India is to be democratic union, and even self-government should also to be empowered. Okay, likewise there shall be a union government. Lok Sabha elections, direct elections, Rajya Sabha elections, indirect elections, state assembly elections, direct elections. Okay, so about elections, it is also talking about the freedom, liberty, okay, liberty of thought and of faith, which is holy in nature, which is brief in nature, which is to be point, so that only equality could be provided, equality of status and of opportunity was given. Thus, by establishing and promoting justice to the people. Okay, so liberty, equality. Not only that, over a period of time, through 42nd Constitutional Amendment Act, what India originally was somewhat replaced. Originally India was socially sovereign, democratic and republic. Okay, so socialist and secular are the two most important words which got inserted along with the unity and integrity, So these are the three most important words which got inserted into the preamble, the philosophical foundation of Indian Constitution, the draft Constitution, okay, through 42nd Constitutional Amendment Act 1976. Is it clear? So this is what the point. So originally India is a sovereign country, democratic country and a republican country. But now India is a sovereign, socialist, secular, democratic and republic in nature. Okay, and thus why sir for all these, in the sense because for the fraternity, the brotherhoodness, so that only equality exists, so that only freedom could be provided, so that only justice could be provided. So this is what the philosophical point of our Indian constitution. Is it clear? Okay, and now the next important continuation here is to understand the word sovereignty. Basically, these are of two types: internal sovereignty and external sovereignty. So basically, what do you mean by sovereign? In the sense, without having any influence, okay, of the external countries. A country like India could take decisions by its own. Is it clear? That is what exactly we call it as sovereignty. Internal sovereignty can be seen or can be given, provided to the citizens of India. Best example is at the time of our right to vote, when we are about to use that. Okay, at that time we were not at all going to be influenced, motivated by any other individual citizen, any other body, any other institution, and hence we can say in India both internal and external sovereignties were existed. Okay, and the next important feature is your secularism, which we have already discussed. Okay, and then comes your socialism, where we are tending towards to establish welfare state. Okay, when we are talking about socialism, welfare state is one of that important feature. And now, based on this itself, Sarvodaya is that concept as the feature of Indian constitution, which refers to the welfare, okay, welfare of the majority, which is your Gandhiji's philosophy, doctrine, Vasudaika Kutumbam concept. Okay, so this is what your socialism was intended to, which we adopted from your USSR. But there are a lot of differences between USSR socialism and Indian socialism, because Indian socialism is a mixed work of Gandhian philosophy as well as Marxist philosophy, whereas in USSR it is absolutely your Marxist philosophy or a blend with your Lenin or Stalin philosophies. Okay, so in India's socialism we are concentrating on what? It is not just concentrating to provide the welfare to the majority, let me say, to not only limited to provide the welfare to the so-called sections, labor or worker sections of the society, whereas it is the Gandhian philosophy where state is going to act as a trustee. Okay, so Gandhian socialism can be seen. Not only Gandhian socialism, as we are also adopting democracy as the feature, democratic socialism is also seen as a part where liberty, equality, fraternity and justice was given as the major pillars for the rise and intended to establish democratic socialism in India. Not only that, there is another significant feature which we adopted called liberalism. Okay, liberalism. In other words, we can say it is nothing but your fundamental rights concept. Okay, so Gandhiism we adopted, liberalism we adopted, not only that, socialism we adopted, and finally our intention is to establish humanism as one of the feature. The silent feature of Indian ideology is your humanism. Finally, our basic intention is to establish humanity, not only in our Indian society but also in the complete world. Okay, so this is what exactly the major features of Indian constitution, and I hope I am clear from my side, and you people just go through the lecture as well as the supportive material which we are providing from the Pragma Education. And this is Shankar again signing off for this module chapter called the features or the characteristic features of Indian constitution. And if you do have any doubts with respect to this chapter, you are free to ask the questions, and we are here to help you out. So thank you very much, and again in the next chapter we will meet with a new parts of discussion where for the first time according to the syllabus, Pragma Education is that which is providing with the examination point of view. So keeping that in your mind, please do follow the lectures very seriously and sincerely attempt the model questions also which we are about to provide. So this is all for the day, and thank you very much.